call you back.
Yeah, no worries. I was already when you were.
Right. To catch up too.
Yeah.
Great, all the panelists are now here. Okay, good afternoon, ladies and gentlemen. My name is Bhumika Muchala, and I welcome you to this Asia Program event at the... Welcome you to the Asia Program event at the Woodrow Wilson International Center for Scholars. I want to first thank our co-sponsors, the Solidarity Center and the Science, Technology, America, and the Global Economy program here at the Woodrow Wilson Center. In particular, I'd like to thank Kathy Feingold and Tim Ryan, as well as our Asia Program team here at the Wilson Center. Trade and labor standards. I'd like to give a brief introduction on this topic. Asian economic regionalism is driven today by active FTAs that seek to intensify economic and commercial integration. No other market is as important to Asia as the United States, which remains its largest trading partner. In the last decade, and particularly in the last 2 years, there has been a proliferation of FTAs between East and Southeast Asian countries, such as Korea, most recently Malaysia last year, Singapore, and Vietnam with the United States. Recently, in May of this year, the U.S. Congress made a trade policy agreement with the Bush administration concerning new labor and environmental standards in all bilateral trade deals with the goal of enforcing labor and environmental standards in FTAs. The agreement calls for the Bush administration to modify all pending FTAs, which currently includes the countries of Korea, Peru, Panama, and Colombia. As is well known in the trade policy and labor advocacy circles, the issue of including and enforcing labor standards through trade deals is a rather contentious and often hotly debated issue, particularly here in Washington. Democrats advocate that better labor and environmental provisions in trade bills are necessary in order to level the playing field and ensure that companies and countries do not gain an unfair competitive advantage by denying their workers basic rights and neglecting environmental provisions. Meanwhile, the leaders of developing countries have generally opposed including language mandating labor standards in trade deals, arguing that such rules are protectionist and would undermine their ability to compete in major world markets, primarily the U.S. and the EU. On the other hand, labor rights advocates in the U.S. point out that there is widespread support for the trade-labor linkage by developing country trade unions and developing country workers. And the findings of a multinational study last year by the Chicago Council on Global Affairs and worldpublicopinion.org found that the vast majority of citizens across both developed and developing countries support linking both labor and environmental standards to trade agreements. Given how crucial trade, market access, and sourcing and manufacturing contracts with American companies are to the export-oriented economies and more broadly to the economic growth strategies of Asian countries, the trade-labor linkage today is an undoubtedly crucial issue for workers, businesses, governments, and economies across the world. The gender dimension is also extremely critical, as the vast majority of low-wage and labor-intensive manufacturing for export is done by young Asian women migrating from rural areas to industrial towns. The panel today will shed light on the gender dimension of the trade-labor debate, the labor rights arguments at hand, the Office of the United States Trade Representative's position, as well as the arguments and views that oppose including labor standards in trade agreements. I would now like to introduce our extremely distinguished panel today in the order in which they will speak. First up is Katrina Coleman, who is Senior Vice President for Global Trade at the Women's Edge Coalition, where she lobbies for U.S. trade policies that address the economic needs of women living in poverty around the world. She's actively involved in a coalition of nonprofit organizations, think tanks, and businesses that are working to create greater opportunities for developing countries through trade preference programs and capacity building. Prior to joining the Women's Edge Coalition, Coleman held the position of Director for Eastern Europe and Eurasia in the USTR. Jeff Boat is the Global Economy Policy Specialist for the AFL-CIO, the American Federation of Labor and Congress of Industrial Organizations. In this capacity, he works to shape international economic policy to the end that it may improve the lives of working people both in the United States and abroad. He has extensive experience in international labor law and practice, as well as international trade policy, and prior to joining the AFL-CIO, he analyzed and worked to reshape U.S. foreign policy toward Latin America. Louis Koresh is Assistant U.S. Trade Representative for Labor in the Office of the United States Trade Representative. In this capacity, he oversees trade and labor issues for the USTR, including serving as chief negotiator of labor provisions in multilateral, regional, and bilateral free trade agreements. He also develops U.S. positions on the relationship between trade and labor across international fora, such as the ILO, the WTO, the World Trade Organization, and the OECD. And last but not least, Theodore H. Morin holds the Marcus Wallenberg Chair at the School of Foreign Service at Georgetown University, where he founded the Landiger Program in International Business Diplomacy and also serves as a consultant to the United Nations, as well as to diverse governments across Asia and Latin America. His most recent publication is Harnessing Foreign Direct Investment for Development, Policy Options for Developed and Developing Countries. He is a non-resident fellow at the Peterson Institute for International Economics and at the Center for Global Development. I will now turn it over to Katrina Coleman. Thank you.
Is this on? Can you hear me? Yes. Hi. Thank you very much. It's so nice to see such a full house this afternoon. And it's a real pleasure to be here. I want to thank Bhumika and the Woodrow Wilson Center for inviting me to participate in this panel and to present to you an aspect of this issue that I think is so incredibly important but is not always discussed, which is the impact of labor provisions and trade agreements and other trade policies on the poorest women around the world. As you heard, my organization, the Women's Edge Coalition, looks at precisely this issue. We analyze U.S. trade and development policies from the perspective of poor women living around the world and try to come up with very practical, creative solutions to how those policies can be improved. I think that there is no question that labor is one of the most pressing issues for women around the world. I think that that's probably true in every country. And over the course of my work in trade policy, I have met a lot of women from around the world who have either suffered tremendously because of the lack of better labor protections or have benefited from solutions that their governments or companies or our government sometimes have come up with to improve labor standards. So I think that I've seen both the very negative side of this and the positive side, and I want to touch upon both a little bit today because I think that there are solutions out there, but I think that there still are a lot of challenges that remain. Women are the majority of the world's poor, and they are very often hit hardest by economic transition. And trade policy, I think, it deals with economic transition on a constant basis. So it's really important to continue to look at trade policy through the lens of how it is impacting the poorest members of society, and particularly these women, since it's very often difficult for them to participate in the system, to have recourse to the laws, even if laws are passed. And I think it's important to keep that in mind. As I said before, we try to find very practical solutions through trade and development policy, and I think that looking at labor standards through free trade agreements and other trade policy vehicles is in fact a very practical thing. I think there's a lot of opportunity presented by the fact that labor is now included in all trade policy vehicles, and I think that there's still a lot more that needs to be done. So I think it's also important to keep in mind that trade agreements alone, and I think that this is true of different types of trade policy, I have until 3:57. Okay. The trade policy alone can't do everything. That we have to look at domestic solutions within the countries themselves, that we also have to look at capacity building, which is becoming more and more a part of every trade policy vehicle, but is something that I think it's also important to keep in mind. And capacity building, I think, has to happen across stakeholders. It has to be geared towards government. It has to be geared towards companies, and it has to be geared towards individual workers themselves. And I will finish today with a bit of a discussion of some innovative trade policy capacity building solutions that I think have worked well in this area and that could provide models for going forward. But I'm going to start with the topic at hand and talk a little bit about free trade agreements, and then say a few words also about trade preference programs, which is another trade policy tool that covers a number of countries, including many, many countries in Asia, and is something that's being debated now. Within the Congress, there are a number of members looking at these issues, including Congressman McDermott, and how the preference programs can be expanded for the world's poorest countries. I think that discussion provides another opportunity to look at how labor standards can be enhanced. And then again, I will end with a discussion of the human capacity side of all of this, and where some innovative solutions have come forward. I will speak about Asia specifically, but we'll also make some general observations that I think pertain both to the countries in Asia and also to other countries around the world. So with respect to the free trade agreements, I think that there have been some notable improvements through the free trade agreements in terms of market access, job creation. And job creation, I think, is a primary goal of international trade, but I think it's also important to keep in mind that it's just one step along the way, and that, for the women that my organization represents, there have been jobs that have been created, but you also have to look at whether those jobs are good jobs, and they are not always good jobs. I think that improving the quality of jobs overseas will both boost living standards in countries around the world, and also does slow the race to the bottom that Bhumika alluded to, which I think is an important thing to keep in mind in all this as well. And including labor standards and free trade agreements is critical to improving the quality of these jobs. We are very hopeful about the template agreement that was announced by Congress and the administration recently, and hope that this will be implemented through the new free trade agreements, and also be implemented through other trade policy vehicles as well, including preference programs, as I mentioned before. And I think that there's just no question that better labor standards would significantly impact the lives of women. One provision in particular has been notably absent from U.S. trade policies in the past, and is part of this new template, and we very much hope that it will be implemented. And that is to include prohibition against discrimination in the workplace. It's one of the core ILO standards. It's something that impacts women around the world, and it's absolutely critical that it be included in any agreements and policies going forward. Of course, better enforcement mechanisms are also very, very important. And it's a lot harder to enforce laws than it is to pass them, unfortunately. So another thing that I've heard from women's groups around the world that I think is very relevant in this context, and this is particularly when talking with them about free trade agreements, is that very often they feel that they are outside of the negotiations, outside of the system, and that even if there are better standards in free trade agreements, that they won't impact their lives. And I think that as we think about how these policies can be improved upon, it really is important to look at how they reach every individual. Because if they don't, then I think that that you haven't really seen a true shift in rule of law. So we need to really look at how to bridge this gap between the standards that we aspire to and the standards that get included in agreements, and then how there's real true change on the ground. And as I said before, many women, even if there are good laws in place, often just don't have recourse to the judicial system. It's very expensive for them to access the system. They don't know how to ensure that their rights are protected, and so just having a law there is not enough for them. So I think that all of this needs to be looked at. So what can be done? A couple of specific recommendations. First, as I've said, I think the standards do need to be improved to reflect the key labor protections, including non-discrimination. Enforcement needs to be a primary goal. Second, I think that the process of negotiating trade agreements needs to be broadened, so that groups that do have different interests are brought into the process more and more, and that I think holds true in many countries around the world. And that participation needs to be both in the consultations on trade policy specifically, and also with respect to domestic legal systems. Third, I think that capacity building needs to be strengthened, and I'll probably say that about 15 times throughout the course of this, because I think that it's something that needs to be looked at in every single case. And fourth, I think that that any kind of trade agreement, any kind of trade policy really needs to be looked at through the lens of its impact on development and how its benefits reach the poorest members of society. We actually developed a tool to do this. It's called the Trade Impact Review. It's something that we have available to the public on our website, and it looks at the development impact of any trade agreement or any trade policy on both women and men. And some of the findings, we've done a couple of case studies. For example, one with Mexico, where the findings showed that, well, the NAFTA did create jobs for women in manufacturing sectors, which I think is something well known. Opening trade in other sectors like agriculture created movement for a lot of women into the informal sector, where there are not legal protections and not labor protections. And I think that in addition to that, there are the health and sanitary conditions and sometimes the other aspects of labor protections that really need to be looked at closely in the context of these agreements. I know well from having been at USTR and having been on the side of the negotiators that it's very hard sometimes to have access to all of this information, and that the groups that do have access to the information sometimes don't have access to the negotiators. So I think that doing a development review would be one way to correct that problem. And as I said before, I think increasing participation in the system itself would be another way to address it. But FTAs are not the only trade policy tool that we have here. As I mentioned, there is also a growing discussion on looking at how the unilateral trade preference programs can be expanded and improved so that they will create as much benefit as possible for the poorest countries around the world. These programs have also led to job creation. AGOA, for example, which is one of the well-known programs, has generated thousands of jobs for women in the apparel sector in Africa. 90% of those jobs have gone to women. Again, job creation, just the first step. Job quality is also, of course, a huge consideration. And also because of the eligibility requirements of these programs, and I don't know, maybe Jeff will say some more about this because I know the AFL has worked on a number of cases under these different preference programs, GSP, AGOA, the Andean program, the Caribbean program. But because these programs all have eligibility requirements and do have specific eligibility requirements on labor, they have actually been an effective way to improve labor practices in countries around the world. And I think that it's appropriate to keep those conditions in there, again, because I think that it helps ensure better labor standards around the world and improvements of quality of life, and also slows the race to the bottom, which is such a concern, I think, for all of us. These programs have an annual review mechanism, and individuals and NGOs and other interested stakeholders are allowed to comment and to file petitions, which I think is has proved to be a very useful process. I think that we could probably look, as we're looking at how to improve these programs, look also at how to strengthen this annual review process. But I have seen it work firsthand. There have been a number of cases that have resulted in the loss of trade benefits for countries that don't comply with the benefits or with the requirements of these programs. A number of them from Liberia to Belarus, which is one that I worked on. Many, many more petitions are filed each year. In addition to that, there are countries that have not been eligible to get these preferences because of issues that they've had with labor. Myanmar is an example of that. And for these countries, that is a bar to actually becoming part of these programs, and I think does serve as a good tool to improve standards when countries are interested in doing that. So we, again, would propose that the standards included in these agreements in these preference programs, be strengthened and do reflect what's in the template that was agreed upon by Congress and the administration. And also think that this is a real opportunity to link capacity building specifically to the trade policy. So there are a lot of areas in which additional capacity is needed: management training, training on specific areas of trade policy, training on developing laws, training, capacity building on trade-related infrastructure. But I think the human capacity piece of this is really, really important. And here I would say just a couple of ideas, and I think that there are probably many, many more. Building the capacity of labor ministries, bringing in expertise locally, internationally, improving worker education, upgrading factories, improving monitoring systems, improving the legal system and judicial capacity, So again, I think a development review would be helpful to find out where some of these gaps are and how best the programs can be tailored to meet them. The U.S. government plays a huge role here. There's a lot of money being funneled towards trade capacity building, currently $1.3 billion, but the commitment is to double that amount to $2.7 billion by 2010. And then I think I just want to close with a little bit more on some of the innovative solutions that some of us have seen really work well, and I think that this probably holds true for all of us who work on these issues. Unfortunately, these are not examples that you see in many, many places, but I hope that that can change, and I think that there's really the potential for that to change. One of these innovative solutions is a project called the Better Factories Cambodia project, which I'm sure many of you have heard about. This originated in 2001. At the time, there was still an international quota system on textiles and apparel, and so Cambodia, in order to get larger shares of that pie, agreed to improve standards in its factories, and there was a monitoring system set up with that. The beauty of this was that it worked, and it involved all different stakeholders across the board. It involved governments. The Cambodian government was very bought into it. It involved the private sector. It involved NGOs. It involved workers themselves. The International Labor Organization was very involved, which I think, and worked very closely with our Department of Labor, and I think that that's something else that, bearing in mind limited resources, is something that we should think about. Unannounced factory visits, one-on-one consultations, off-site consultations. I think all of these are very important aspects of how to make sure that monitoring is working well, and they were all incorporated into this. And also, in addition to improving labor standards, what this did was improve quality and productivity. So it has been a successful program, and I think that we need to look at how current trade policy can incorporate programs like this. Over the last couple of years, I have also gotten to know the apparel sector in Sri Lanka. And this is another example of where the multi-stakeholder approach can really, really work to produce tremendous results. I've worked primarily with a company there that has about over 40,000 employees. Most of them are women. And they've put in place a program to increase the skills of all of their women employees in each of their factories. And they have a number of factories. And the program is called Women Go Beyond. And I've visited, I think, probably about half of their factories. I've met the women who are beneficiaries of this program. And it addresses very basic elements of their lives, but the end result is pretty transformative. It's healthcare, it is transport to and from work, cafeterias on site, athletic training, banking machines, which are virtually unheard of in many parts of the world and give women freedom that they had not had before. And then training on all aspects of their lives, everything from financial planning to how to deal with domestic violence, to how to deal with workplace issues, to information technology, which has prepared women for opportunities in other sectors after leaving the apparel sector. The results for Sri Lanka, I think, have been tremendous too, and just as Cambodia did with the Better Factories Cambodia program, Sri Lanka is differentiating itself based on higher labor standards. What this allows the industry to do then is carve out a niche for itself in higher value added and high quality products, and become a trusted supplier for a number of U.S. companies. And Sri Lanka has now moved to do this countrywide with a program called Garments Without Guilt, which some of you may have heard about. They were recently visiting Washington. So I hope that these kinds of programs are just the beginning. And I think that there's a lot more to be said on this topic, but I think I'm out of time. So I'm going to turn it over to my other panelists and look forward to hearing all of your questions. But I think that, you know, the opportunity for us and the challenge for us is to look at how every aspect of trade policy can address these issues and to try to find the most innovative and the most creative solutions, which are usually those that involve all of the players, all of the participants, all of the stakeholders in these issues as well. So thank you very much, and I look forward to your questions.
Thank you all for coming. My name is Jeff Odom with the AFL-CIO, and there I work on international labor standards and international economic policy. So I think there have been two titles to this program. One, can labor standards in Asia be enforced through free trade agreements, and later it was changed to should labor standards be enforced through trade agreements in Asia. So I'm going to try to touch on both of those questions. Although I'd start out by saying it's over the last 20 years, labor standards have been linked to trade preference and bilateral trade agreements, and they've been mandated in Trade Promotion Authority legislation. So I think in our view, the question of whether labor and trade should be linked is no longer really at issue, although I'll restate some of the reasons here for some of you who may not be familiar with the arguments on both sides, though I'll be arguing for my side. But there are still questions as to how to best operationalize this linkage, and Katrina touched on some of these issues. I could talk endlessly on this, and I won't, but I'm going to focus on a few things here. The labor standards that we've seen in trade preference programs, in our trade laws, in our bilateral trade agreements, although you see linkages in OPIC legislation. The ILO itself has some capacity to, beyond just its moral suasion, also, in the case of Burma, for example, is use its constitution to call upon member states to sanction Burma. So there are a lot of tools out there. Unfortunately, I think one of the problems has been that these tools have been used inconsistently or not at all in many cases, and this has unquestionably an impact on how people view the efficacy of these tools and the way these tools are used. Certainly, political decisions, commercial decisions have shaped the both in Democratic and Republican administrations the use of these trade-related labor standards. But whatever the problem with these existing measures, whether they're clumsy, there's lack of political will, or so forth, I think they still are essential and linked with international campaigns, international labor union solidarity, and so forth. It does create the political space for positive change, both in law and in country practice. And I would also emphasize that worker representatives in developing countries, and the ones that I have talked with personally in Asia, are supportive of this linkage and have attempted to use it in the past, either with U.S. colleagues or with colleagues in the European Union. So just briefly to go over the basic argument for linking labor standards in trade. First, we believe there's a valid justification that the kind of distributional and human rights concerns do justify the linkage between trade and labor, and that having the ability of the world community or the U.S. or other major trading partners imposing these standards, it does create the political space to push up labor standards internationally. And then also, it's also been argued that the absence of labor standards or the suppression of labor standards is a legitimate trade issue, just as the absence of intellectual property protection. And you could argue that there's a little difference between a country giving a subsidy to an industry and the similar industry also suppressing labor rights. One of the key arguments you also hear is that this is a protectionist thing, that the countries are using this out of their own self-interest. And again, I think the first response would be most of the products we're seeing coming from developing countries are no longer produced in the United States or Europe. So the idea, there may be some exceptions, but I think largely there isn't a market here that we're trying to protect with these preference programs. And then the linkage with trade or with labor standards. The second, we see with, especially in FTAs, that there's an independent international tribunal that's making the decision as to whether labor rights have been violated. It's not the complaining party itself. And then I would also have you look at the empirical evidence with the GSP over the last 20 years and look at the claims that have been brought under GSP. And I don't think you would find that cases brought under GSP and the cases that the AFL have brought under GSP have always been brought with both in partnership with developing country unions. Do not show that these were brought for the purpose of protecting any particular American enterprise or sector. And finally, the use of this trade labor linkage is not damaging to developing economies. And in fact, the OECD has pointed out in a number of reports, one in 2000, International Trade and Core Labor Standards, that countries which strengthen their core labor standards can increase efficiency by raising skill levels in the workforce and by creating an environment which encourages innovation and higher productivity. And in '96, they put out a much more comprehensive report called Trade, Employment, and Labor Standards that concluded that any fear on the part of developing countries that better core standards would negatively affect either their economic performance or their competitive position in the world has no economic rationale. So, and finally, I would say that developing countries resisting a trade labor linkage are pursuing losing strategy, in that it gives the perception, certainly, that the reason why they are opposing linkage is that they intend to compete on the basis of low cost, low wage, kind of exploited labor. And I'd argue that such labor exploitation would undercut employment in that country and elsewhere. And further, that perpetuating this idea that countries need to compete on this lowest cost, lowest condition basis is going to weaken support for trade generally and market opening. And I think that's certainly not what developing countries are trying to do. I want to quickly go over a few examples of how GSP has been used in Asia. I would cite two examples where, unfortunately, the U.S. failed to act, and labor standards continued to this day to be quite low. Two examples where the U.S. did act. There were partial victories, and then we filed just one this year, 2007, against Bangladesh. It's our fifth petition, and I guess the jury will be still out on that one. But in the 80s and 90s, Malaysia and Indonesia were really exemplars of the kind of Asian economic model. And from the trade union point of view, this was accompanied by suppression of democratic freedoms, labor rights, in an effort to foster kind of an economic and export climate in the country that was favorable to international investment. As you know, Malaysia at the time became a center for electronics manufacturing and the creation of the pioneer industries and the export processing zones. Indonesia also had a vast kind of natural resources, oil, gas, tin, and later became a major exporter of footwear and other apparel. In Malaysia, you had real labor rights repression. Unions were only government-sponsored unions were allowed in the electronics sector. Collective bargaining was seriously limited, and really nullified the ability of workers to really kind of bargain for better conditions in those sectors. And in Indonesia, it was even more troubling. You had at that time armed security guards roving the factories. The military had stepped in several times to break strikes and protest movements in the country that were demanding higher wages and better working conditions throughout the country. In 93, 94, there was a series of strikes that strike leaders had been tortured and murdered. And in 1995, the ILO had accused the Indonesian government of murder and the abuse of trade union rights and demanded that the government punish those involved. In 87 and 88, the AFL-CIO and other organizations began filing GSP petitions, both against Malaysia and Indonesia. At the time, in 89, the USTR rejected a petition on Malaysia, saying that they had been taking steps in line with the law. At the same time, the trade representative at the time, Carla Hills, had written to the Malaysian trade minister saying, quote, "Your government does not allow full freedom for workers and to associate and form labor organizations of their own choosing in certain export industries such as the electronics industry. Your government Pioneer Industries program restricts collective bargaining at firms with foreign investment." So at the same time, the government was saying that these problems certainly existed. They said that Malaysia was taking steps. Another agreement petition was filed in 1990 on Malaysia. It was again rejected because it, quote, had no new information. Another petition was filed against Indonesia in 92, but unfortunately, in the weeks following up to the APEC summit in 1994, Clinton had traveled to Indonesia for the APEC summit. The petition was denied. And the decision to deny the petition came 1 week after the arrest of 19 Indonesian trade union leaders for publicly criticizing the weakness of some of the labor reforms that had been passed in response to the GSP review. And one of the leaders of the Independent Labor Federation had been arrested, tried for treason, and faced the death penalty before international outcry converted that to 7 years in prison. Some of the laws that were complained of in the 80s and 90s are still the laws of Malaysia today, and the labor movement there is still facing significant hurdles. With Thailand and Pakistan, we did see some advances with the use of GSP. In 1992, the AFL-CIO had filed a GSP petition on a number of issues, but one in particular on the State and Enterprise Labor Relations Act of 1991, which essentially banned trade union organizing and collective bargaining in state-owned enterprises. In 2002, the government finally did comply, passed an amendment to that law, although there's still real restrictions with collective bargaining among the state enterprises. And in Pakistan, as we all know, in the 90s there was a lot of focus on child labor, particularly in carpet manufacturing, soccer ball industry, surgical instruments. And I think the shock around child labor really was galvanized when a child labor advocate, Iqbal Masih, was 12 years old, was murdered in 1995. And in 1996, the Clinton administration acted and suspended GSP preferences to certain products from Pakistan. Since then, that has created kind of political space for a number of projects. The ILO, IPEC, has been working in Pakistan for several years, trying to promote better working, remove children from that work, to put them through education, monitoring of child labor in those sectors. And there have been convictions for child labor law violations in Pakistan, although the penalties are still quite low, and obviously there are still many cases where children are still working and not are not being detected by labor inspectors in that country. And as I mentioned, we have the case against Bangladesh, where since 1990 we've been trying to address some of the systematic violations of free association and collective bargaining in that country. So we have a very mixed picture with the use of this mechanism, which is not to say that we want to throw it out. We think there are ways in which it can be improved, and I think ways in which we will advocate for in the context of what Katrina was talking about with McDermott and others are working on kind of an omnibus sort of trade preference program and working to improve labor standards, including the addition of non-discrimination and hopefully eliminating some of the excessive liberty of the U.S. government to determine whether or not to move on well-founded and substantiated complaints. I have 4 minutes to finish, so I'll skip China. And And move on to Cambodia again. I think I would agree that Cambodia has been a model that I think has produced real results, at least for the time that the program was in existence. It did link greater access to the U.S. market on the government complying with basic international labor standards, and push the ILO for the first time really to take a new role for itself and monitoring factories, in monitoring at the factory level, and I think this had for its time improved working conditions significantly, as well as added significant employment in the textile sector. In '98, before the agreement took effect, there were about 80,000 workers in that sector, and at the end of 2003, the apparel employment was about 220,000. So it was a dramatic increase in employment. And I think the ILO monitoring, although there are some legitimate concerns with kind of some of its transparency and the ways in which they did or did not reach out to unions and workers, which I'll gloss over, I think overall it was good. And when there was, in the first round of inspections, when problems were identified in second rounds of inspections, not in all cases, I think about a third of the factories, nothing had improved, but in others, you did see wage and overtime issues being addressed. In some cases, some of the freedom of association issues being addressed. Unfortunately, though, I think the program has been wrapped up. And if you just look at the human rights report of the State Department for this year on Cambodia and worker rights, it does mention that in June of last year, 200 riot police forcibly broke up a march involving 1,500 workers protesting the illegal suspension of a union leader and urging a garment factory to comply with an arbitration award. Some of the legal provisions still allow, don't protect strikers from reprisals. And there are reports that the workers were dismissed on spurious grounds. So with some of the spotlight off of Cambodia, new problems have emerged, or old problems have re-emerged rather. So I think continuing monitoring of that situation is necessary. And with regard to the FTAs, obviously we're very supportive of the new labor language that was negotiated between the administration and the leadership of the Democratic Party, and particularly with the assistance of Rangel and Levin of the Ways and Means Committee. This new language has been implemented or into the draft or the negotiated U.S.-Korea Free Trade Agreement. The U.S.-Malaysia Free Trade Agreement was not concluded before Fast Track expired, though I understand that there is a continued push to negotiate that agreement to conclusion. Although unfortunately throughout the negotiations, I think the Malaysian government has been extremely resistant to any labor trade linkage, and only recently towards the end of negotiations began to cool somewhat to the idea. So with regard to FTAs in Asia, it's still an open question as to whether the new language, which again requires, in the case of Korea, to maintain and adopt laws that are comply with the ILO core labor standards as articulated in the 1998 declaration, whether those will be enforced owing to the political will on this side or on Korea, it's an open question if that agreement actually is ever ratified. But I think I'll end it there as I'm already over time, and be happy to take any questions.
Just wanted to mention that we will have ample time for a question and answer discussion session after all the panelists have had a chance to speak. And next is Louis Koresh.
Thank you, Bhumika, and thank the Woodrow Wilson Center for having me here today, and thank all of you for coming. I see a lot of familiar faces and hopefully some friendly faces as well. As Jeff pointed out, the title of the program is Should Labor Standards Be Included in Free Trade Agreements with the United States? From our standpoint, it seems as though this question has already been answered. We, of course, most recently have this bipartisan agreement on trade, and the new labor provisions have been included in the FTA with Korea. They involve the most advanced labor provisions that we've had in any of our bilateral trade agreements up to this time. Trading partners, of course, as well as the United States, are committed to adopt, maintain, and enforce the fundamental labor rights as stated in the ILO Declaration. And for the first time, these fundamental labor rights in an FTA are subject to the same dispute settlement provisions and the same remedies as commercial provisions. This is distinguished somewhat from the Singapore FTA, which had been negotiated previously and has been enforced for several years now. Was also negotiated under the current TPA, but the only enforceable provision in the labor chapter there is to effectively enforce your labor laws. There are, of course, references to the ILO declaration, but the provisions are to strive to ensure that the principles in the declaration are recognized and protected in law. The current language that has been included in the Korea FTA and our other recent FTAs goes further even than the FTA we have with Jordan, which many people who have been promoting trade and labor linkages, often hail as the best practice, as the best agreement on labor provisions that we've had. This new template goes further than that. It's no longer the strive to; it's a hard obligation, and it's fully subject to dispute settlement. So, what is this new template? What does this linkage mean for the region, for the Asian region that we're here today to talk about? Well, I think first it's important that we take a look at the overall significance and nature of our trade with the region and how it has been changing, particularly in recent years. I mean, Asia now accounts for 1/3 of total U.S. trade, which is up almost 70% over the last 10 years. U.S. investment has more than tripled in the region over that same period. Even more important is the transformation in the Asia-Pacific region from the center of low-cost manufacturing to higher-skilled products and more advanced manufacturing. If you look at the composition of our trade with Asia over the last 7 years, you'll see a significant change in a higher degree of trade with higher skilled sectors like electronics, and that is about 6 times higher than our trade in for example, say apparel products, which is generally considered a lower skilled, lower technology-based sector, and that's been fairly consistent over the last several years. This growing technological sophistication, increasingly skilled workforce, also, I believe, is reflected in rising wage rates in the region. The reality is that Asia is increasingly becoming a driver of global trade because of these changes, which are quite significant. And from our standpoint, we should be deepening our relationships with the region on trade issues. We should be working with them to create economic reform, adherence to rules-based systems, create better capacity and more competent institutions for enforcing the law and administering the law, and promoting worker rights and strong industrial relations systems is certainly a part of that effort and an important part of that effort for some of the reasons that you've heard our previous speakers talk about. And the reality is that most of this region is no stranger to addressing worker rights issues through trade agreements and trade relationships with the United States. This has been going on for quite a long period of time. The most recent, obviously, and the strongest provisions are the provisions that are in the FTAs with Korea and Singapore. We've had FTA negotiations with Thailand and Malaysia. Both of those negotiations have included very frank discussions about labor issues and industrial relations schemes, where there's positive things and where there's shortcomings in their law and practice. And we have held those countries to the same expectations as our other trading partners in FTA negotiations. Of course, during those negotiations, we did not have this new bipartisan template, but the Malaysian negotiations in particular, they certainly were aware of potential for some further reforms or changes to the U.S. view in these areas, and I don't think the new template should really have come as any surprise to the Malaysian government and the Malaysian trade negotiators. Those negotiations, of course, continue, and we will see how those work out in the end. In addition to the trade negotiations, we've had trade preference programs in the areas for a long period of time. GSP, with the exception of Burma and Laos, all of our trading partners in the region have agreed to abide by some form of labor provisions, either in the FTAs or GSP or TIFAs, Trade and Investment Framework Agreements, or some combination thereof. The GSP standard on worker rights, which is to have taking steps to afford internationally recognized worker rights, has been in place since 1984. And certainly, as Jeff pointed out, it has been an issue, and labor rights cases have been raised with some of these trading partners, and we have addressed labor rights with them to varying degrees. Obviously, GSP itself, even without a deeper relationship of the full bilateral trade agreements, creates a real incentive for countries. I mean, you're talking about real money, you're talking about real trade. The loss of trade preference programs is significant for these countries, and in fact, the labor rights provisions in the GSP does bring the countries to the table to discuss means to address concerns that there may be. In the region, Cambodia, Indonesia, the Philippines, and Thailand have all benefited from GSP. And of course, the worker rights issues, as I mentioned, have been part of those various discussions at differing times. In one particular case with Thailand, throughout the 1990s, there was several issues raised, in particular freedom of association and child labor issues. And in fact, this dialogue at least partly led to passage of new labor law in 2000 in Thailand. As I mentioned, we also have the TIFAs. The TIFA standard, while a little different than obviously our full FTAs or even GSP, is not a binding standard, but it's another building block for dealing with worker rights and labor issues with our partners. All of our TIFAs have had language, at least our recent TIFAs, have had language addressing worker rights. The most recent language has been along the lines of recognizing the importance of providing adequate and effective protection and enforcement of worker rights in accordance with the nation's laws, and a commitment to improve the observance of internationally recognized worker rights. This language certainly is in the Malaysia TIFA, and it's in the most recent TIFA with Vietnam as well. Similarly, there's language in recent TIFAs with the ASEAN and with Cambodia. Now, by mentioning the fact that we have these worker rights provisions in GSP and TIFAs, and we've had for quite some time, I certainly don't mean to imply that because of that and because of dialogue with the countries, that somehow this means that all the problems are fixed, that these countries don't continue to have issues both with regard to actual labor law and enforcement and application of that law. But certainly it means that it has created a dialogue with these countries, and it is a dialogue that we use on a regular basis, both through the GSP petitions and through our regular dialogue through our TIFAs that call for annual meetings with countries. And in fact, the worker rights issues in countries where there are worker rights issues are on the agenda on a regular basis when we have our regular TIFA meetings with our trading partners. This is a standard that's still evolving. As I mentioned, of course, we have the new FTA template that has been included in the Korea agreement. We don't know exactly how the Malaysian and Thailand negotiations, once they have a democratically elected government in place, and we can continue those negotiations. We, of course, don't know exactly how those negotiations will progress, but certainly the labor rights issues will remain on the table and would continue to be addressed, and we would presume, of course, that we would continue to address them as we have done with Korea and our other recent partners. It's not clear also how the worker rights language will progress in other U.S. domestic language. Obviously, our trade preference programs come up for renewal in Congress on a regular basis, and how Congress may choose to take up the worker rights provisions, of course, is still not known. But I think any of us familiar with this area would presume that Congress would continue to push on those issues and would continue to insist upon provisions in our various trade preference programs and as we move forward with TPA renewal discussions as well. We can see part of this debate playing out in Congress on current discussion of reauthorization for OPIC, Overseas Private Investment Corporation. The House recently passed legislation for renewal of OPIC that included some new language on and mandates on worker rights provisions, including the notion of OPIC giving preference for projects in countries that have adopted and maintain and enforce laws that substantially provide for international worker rights. So I think if you look at that language, you'll find some similarities between the terminology used there and the terminology that has been used in the most recent bipartisan template. Let me also mention, as part of this evolving standard, certainly trade capacity building, particularly on labor rights and environmental issues, has also been part of the equation. Of course, with regard to our CAFTA trade agreement, there was a commitment as part of that ratification by the Congress for significant funding for labor and environmental issues, and in fact the administration has requested that funding each year, and Congress has provided it, and there's extensive interagency process along with social partners to continue to build those projects and work closely with the Central American governments to improve labor law and enforcement. Similar kind of discussions are out there with our other trading partners. All of our trade agreements include cooperation mechanisms where we commit as governments to work together to improve labor standards and to further our mutual interest, not only bilaterally but in multilateral fora and other areas. So in conclusion, as I began with, it seems to us as though this issue has already been answered. Clearly there is a connection. Clearly there is labor provisions within our trade agreements, and I don't see any reason why that would not continue. Remember, the focus here is really on fundamental labor rights, and I think this is an important point. The ILO Declaration in 1998 has been a particular driver behind this. These aren't some kind of labor standards that the United States has established and is insisting upon, or that the European Union has established. These are fundamental labor rights recognized by all members of the ILO, of which almost everyone in this region is a member, and those that aren't, I feel confident, support the fundamental labor rights as well. And the reality is that these are really akin to human rights. And when we talk about providing these rights, we don't mean that that all countries have to have the same wages or the same minimum wage, or that all countries have to have the precisely same safety standard or some other kind of workplace standards. What we're saying is all countries, regardless of economic development, which is what the ILO has recognized, should be able to provide for the fundamental rights, the basic worker rights for all workers. To us, I mean, not to include labor protections in trade agreements would really be embracing a notion that somehow goods and services are magically produced and magically traded around the world without workers. And to us, of course, you really can't talk about trade unless you're going to focus on the workers who produce the goods, ship the goods around the world. And what we should be doing through trade, and what we intend to do through increased trade, is to improve the lives of human beings around the world, which starts with the right to a safe workplace, free from discrimination, and respect for workers' fundamental rights. No one maintains that developing countries should overnight be able to deal with situations of extreme poverty, or to eradicate child labor, or to reach the highest levels of labor standards, but I think certainly they should aspire to, and the United States certainly should prod them to do so, as our place in the world allows us to do, and should assist them to do so, which is why we have capacity building mechanisms and try to provide resources to do that. So from our standpoint, I think we really ought to stop debating the point as to whether labor provisions should be connected to trade and whether there should be a linkage, and we should just move forward and work together to make sure that we improve the lives for all the workers through this means, which provides, I believe, a very strong leverage point in the world. Thank you.
Ladies and gentlemen, please excuse me for having to stand up here, but it's the only way I guess I can work the PowerPoint that I provided. It does not mean that in Georgetown fashion I'm going to call on you, so you can relax about that. I have something a little bit different. This coming fall is the 30th anniversary of the ILO Declaration on Multinational Corporations and Decent Work. And I've been asked by the ILO to write a paper on what has happened between multinational corporations, not just U.S. corporations, all multinational corporations, and decent work, and then to discuss what are the implications for using trade agreements to enforce labor rights. So I'm going to, if you can endure 6 minutes of fairly good news about multinational corporations and decent work, then I'll get right back into trying to focus on labor standards in trade agreements. So I start with MNC investment and developing country workers. I think the place that most people start from is to say that most multinational corporate investment takes place in least skilled garment, footwear, and other kinds of occupations like that. But the data show otherwise. Most MNC investment from Europe, from Asia, from North America flows into more advanced industrial sectors. I think that here what I'm going to show you overlaps with what Louis told you precisely. And it's not even close. So if you look at all electrical equipment, electronics, semiconductors, auto parts, industrial machinery, chemicals, medical equipment, pharmaceuticals, all of these kinds of middle-skilled occupations, the MNC flows are 25 times greater. So it is really pouring into this kind of middle-skilled industrial occupations. This is academic. If you don't look at the flow, if you look at the stock, you've got a comparison that is 10 to 1. You can adjust this for subcontractors. You can do various adjustments, and when you look at my paper, you'll see I've done all those. But basically, this is where multinational corporate investment is headed. And wherever multinational corporations are located, and recall, I'm talking about Ericsson and Volkswagen, as well as American corporations, as well as Japanese, and increasingly developing country, you find that foreign-owned firms and plants pay higher wages on average than comparable, not than average, but than comparable local firms. And as they engage in increasingly more skilled occupations, they pay 2 to 3 times as much for basic production jobs. So if you look at even just the most basic production jobs in a Volkswagen plant or in a Hewlett-Packard plant, in comparison to a garment factory or a footwear factory, you find 2 or 3 times as much for basic production jobs and 10 times as much for technical and supervisory personnel. And they provide, actually, I should have done a separate slide for gender-related stuff, because this is great news for non-discrimination and for training for women. If they can get out of the garment work and out of the footwear factories, and promotion, you have higher, again, not even in the United States do you have comparable supervisory among genders, but you have much higher proportion of women supervisors, and the promotion is closer to the basis of merit. Now, note, I'm trying to maintain eye contact. This is not perfect. There are lots of exceptions. There are exceptions in San Diego, just as there are exceptions in Kuala Lumpur. But in general, statistically, you find that this is a more positive story. Well, this is more, then there is a lot of survey data to show that you have more classes, you have better protection, more security, you have better transportation, buses, I mean, things, when you're going to an Intel plant or when you're going to a Toyota plant, it's just a different kind of thing. I'm sure that you find, Jeff, you find exactly the same thing. Now, that's the end of the good news. You still find MNC investments, of course, in least skilled activities, and they may pay better, more than local, but it's still, they pay very little, and the working conditions don't tend to be as good. The safety conditions don't tend to be as good, and the MNCs, or more frequently, of course, the subcontractors, often have various kinds of violations. So what I said in the first, I don't think it was even 6 minutes, but the first good news portion does not, should not obscure this. So now I get back to what we've been discussing here, except that my assignment from the ILO is slightly different. It says, okay, let's not look at FTAs. Let's begin to consider analytically, it's hypothetical, begin to consider what dispute settlement and enforcement of labor would look like within the WTO. In Geneva, they don't have any better idea than we do in Washington whether that will happen or might that happen, but that's the next step. So I've started to try to address that. Now, the appeal, as we've heard from most of our colleagues, of inserting labor standards into trade agreements is to induce employers to improve the treatment of their work, to avoid punishment, in particular blocked access to export markets. Well, I just said now for the third time, this is all hypothetical, so help me if you think I'm off here, but this is the way I think Geneva, and therefore I, and probably eventually Washington, will be trying to think about this. The options for dispute settlement and enforcement range from targeted sanctions. These would be Article 20 exceptions, so you can think tuna, dolphin, shrimp, turtle, convict labor exceptions, to across-the-board broad retaliation lists, which incidentally is the format of the new template in the FTA context that we have now. And the first question is, who should be the recipient of the potential punishment? And if you have targeted sanctions, the narrowest target is to say the owner of the plant or the kinds of operations that have persistent violations of one of the core labor standards. Now, everybody who's dealt with this knows there's a kind of a catch-22 here, because it runs the risk of hurting the very workers who are being abused. I mean, you punish the plant where the abuse take place, and that's why many NGOs, in fact, insist that not happen. They go in and try and work with them to make sure that they don't just get laid off, or the guys don't just move to the next country or something. And if you do it plant by plant or even section by section, it isn't a very powerful deterrent. So the more powerful option would be to apply sanctions across an entire zone or an entire industry or an entire sector where enforcement could be shown to be weak. But here the problems are magnified because the enforcement punishes the virtuous plants and workers as well as the guilty plants and workers. I don't know how to go back to there. So let's, in your mind, go back there. You're punishing the virtuous, because I do need help on this. Because you talked about preferred supplier arrangements. And if you have Nike and Fila, I know in popular parlance, people think Nike is the bad guy, but in this audience, I mean, the sophisticated Nike, of course, has many more mechanisms than the average firm to try and do this. And they go out and they say, okay, we'll give preferred purchase contracts if you meet our standards that we expect. And then you get into the debate, do you have public transparent auditing and all of that kind of stuff. But in any case, the benefit for their subcontractors is preferred purchase. Well, if you can retaliate across the entire garment sector or against the entire footwear sector, then this mechanism to ensure compliance goes poof. I should have done a slide on this. The Fair Labor Association now says if you are a member, then you have to abide by our code and you have to be inspected according to our rules, and then you get our certification. But the Fair Labor Association could no longer say in a WTO system, and indeed, unless I'm mistaken, I don't think in this new template, they can't say, we assure that if you meet our standards of the FLA, that your contracts will be honored in comparison to people who aren't members and who don't meet our standards. So I'm worried about that link. Okay, I have a third example, which I said I shouldn't mention companies, but I did, I will. Costco supplier relationships. I don't know how you feel. I'm taking them as the good guys. Could be disrupted to pay for the possible sins of Walmart. I said possible sins. I'm not prejudging. But what I'm saying is if you have big distribution people of different kinds, you know, the ones who may be committing violation, I really shouldn't go there. I don't know what these companies are doing. Maybe they're all virtuous, maybe they're not. But in any case, the ones that are less virtuous are gonna, this really is gonna pull them down. Okay, I'm at my conclusion. Even more worrisome from my point of view is the impact of the enforcement mechanism that targeted entire sectors. Oh no, I am past this. Okay, most dangerous of all in this would be an enforcement system that allowed those who won trade and labor standards cases, and as I interpret the new US FTA template, to choose the sectors. So you lose a case, you get to retaliate against a certain amount, then it comes into the US system, but I warn you now, from my point of view, or it goes into the EU system, or it goes into the Japanese system. I mean, I'm not just thinking about Washington. And then they figure out what's going to be the most painful to try and enforce compliance. It's a virtuous goal, but it's deliberately. And so I say it'd be a very powerful enforcement tool, but it would provide hard-to-resist opportunity for firms and workers who fear dislocation from not using this mechanism to protect themselves. Let me say I agree with Jeff about the history of this and about GSP. I don't think this has been used for protectionist purposes in the past. So this is focusing on the future and what might happen in the future. But remember, I'm arguing that this multinational investment is going to increasingly higher skilled occupations, is actually bringing people out. And I'm afraid, I'm eager to be unpersuaded of this. I mean, so help me if I'm wrong here. But I am afraid that if you had this kind of retaliation, let's see, I did. Okay, I said Ericsson and Intel could be punished to remedy abuses of Nicaraguan migrant workers in the banana plants of Costa Rica. Remember when we were in Costa Rica and we saw the migrant worker problems coming from Nicaragua. So there's no doubt there's going to be, that there are problems there in Costa Rica. And if you had a retaliation list, who would you pick? Intel is the biggest, most powerful one. You try and turn them, you try and poke them so that they could put pressure. Well, you know, this is what I see, and my fear is that therefore these kinds of cases could be brought in ways that would have a protectionist impact, so that you have not just workers, but firms who say, well, you know, we could slow outsourcing to India by bringing a child labor case. Remember, can we bring child labor cases against India? Of course. I mean, you know, that, and it probably wouldn't be hard to win some of those. But if you get into this kind of dispute settlement, you know, you have people pushing for, well, let's try and dampen down outsourcing by going after child labor. Now, this is the kind of dilemma. Maybe we can avoid it, but I think we have to look at it clearly before it happens. I mean, remember what happened to intellectual property protection and whether or not that's such a good idea. I mean, at the time we thought it was, and now it's the most controversial thing around. So what I'm trying to do is say, let's look at this with a little bit of clear sight before we head too far down in this direction. Thank you.
The floor is now open to questions. I just have a few ground rules for asking questions. First, wait until the microphone comes to you. We are being webcast. There's a camera there. Everything's being recorded, so we'd like to hear your voice. Second, identify yourself and your affiliation. And third, keep your comments brief. As you see, we have a full house here, and we want to give everyone a chance. Okay.
Hi, my name is John Foote, and I'm a summer associate with the law firm of Sandler, Travis, and Rosenberg. And I'd like to direct my question to Mr. Karish. I'm curious, I noticed on your bio that you worked on labor provisions and helping draft these things for the last 18, 20 years. And I'm curious as to what well, I just think it's a unique perspective on the history of it, and what your vision is for what we might aspire to and what we might hope for in the next 20 years. Sort of what is the most we might be able to expect out of the United States to be accomplishing on behalf of international worker rights. I mean, is it simply the application of these basic ILO standards to every trade agreement the United States has? Is that sort of the most we might aspire to or hope for from the United States in helping bring pressure to bear on the issues that concern everyone in this room, or do you have a vision of something that goes more than that? So it's sort of a personal question, but also, you know, what we might expect from the United States, and other comments as well would be welcome.
Okay, we're going to take 3 questions at a time to make this a little bit more efficient. So we're going to take 2 more questions. Gentlemen here.
Thank you. My name's Tristan Reed. I'm with the Development Research Group at the World Bank. I had a question in relation to these models that Dr. Morin just talked about, these different models of enforcement. You could target the individual firm, the sector, and then I assume also the entire country. And then there's the element of who gets to choose which sector and which country and which firm. Can any of you speak onto, I guess, the implications of this for improving workers' rights? So have you seen different instances where these different enforcement mechanisms had resulted in an improvement or a greater improvement, or at what level of improvement, I guess? So yeah, thank you.
Okay. Just open it up.
Well, it's a bit of a loaded question, but let me try to respond. I mean, I think right now our focus is on the current bipartisan template and the 4 new agreements, and you know, this is obviously, I think, a big step. It does a couple of things. One, it addresses many of the criticisms that have been out there for some time about the labor provisions in our other agreements, and you know, it helps to rebuild bipartisan consensus for trade more broadly. So I think what we'd like to see is these 4 trade agreements approved so that we can get these into force, and then we can see how these labor provisions work. Of course, these are government-to-government agreements, so you need governments to decide that it's necessary to take action and raise the issues with the other government. all the agreements provide a mechanism for public input through a public submission process where you can raise the issues with the government, but ultimately the government has to take the action. So, certainly from that standpoint, I think this is these are new. These are a big step, a significant step from where we were, and it's important to get these into force so that we can see how they operate and see what kind of effect they might have. Particularly where there's views that there are the gravest concerns. It has, I think, an impact beyond even the 4 trade agreements, because it sends a message to our other trading partners, those that we have FTAs with, or those that desire free trade agreements with us, or those that just wish to deepen their relationships. And in fact, you can already see that impact in some degree, because countries that have an interest, whether we have a TIFA with them and we have those discussions, or whether it's just other countries that say they want trade agreements, one of the key issues they come to us to talk about, it used to be they'd come and they'd talk about intellectual property or how which tariffs could be reduced, but now they come and they want to know about the worker rights issues. What would they have to do in order to have an FTA with us? What would they have to do in the sense of what issues need to be addressed? So I think you're already seeing that kind of an impact. You're also seeing an impact outside the governments with the social partners. I think you're seeing changing interest in the business community, multinationals and others, about how can they address these issues. They want to work with the governments. They want to work not only with the U.S. government, but they want to work with the governments, of our trading partners. There's migrant worker issues. You see a lot more workers crossing borders, which involves not just receiving countries, but sending countries. One example of this is we have a trade agreement with Jordan that has labor provisions in it, and last year there were some concerns raised about worker rights issues in Jordan, and the Jordanian government, I think was very proactive. They engaged with us. They worked with the workers. They worked with the business community and the NGOs that had raised the issues to try to find ways to address them, and we're continuing to do that. And one of the reasons for that was our trade relationship and the importance of keeping that trade relationship healthy and keeping it moving forward.
I mean, just to follow on, I agree with what Lewis is saying, but I think the use of GSP brought it beyond Asia, but it has had the effect of obviously being able to bring a country to the table to discuss serious problems with labor relations in a country. GSP petitions are not filed because of a single, somebody doesn't get their overtime pay in a factory. These are usually very serious cases that are systematic, and for example, there have been a series of GSP petitions against Guatemala, and they usually had the impact of being able to get some incremental changes, improvements in the labor code, and at least in some of the cases that were cited in the petitions, to at least be able to resolve those cases. And again, the idea has not been to block imports from Guatemala, but trying to use this as a leverage to open political space for change. With that said, I think thinking that labor clauses in trade agreements are the kind of silver bullet for fixing labor relations in developing countries, obviously it's not the case. And, the Solidarity Center, for example, has offices around the world where we try to engage in capacity building with our trade union partners, skills workshops on collective bargaining, and helping them out in kind of the defense of their labor rights in country. I mean, think of other trade capacity building that's directed to actually improving the capacity of workers to defend their own interests are essential. So, yeah, this would be one tool of many, I think, to make change.
Okay, do we have any other questions?
Thank you. I'm Helen Raffel, a retired economist, formerly with the Commerce Department, and I'd like to address a question to Ms. Coleman, because as far as improving the status and economics of women and children, I have two problems with trying to address them primarily through international trade and attempting to have the workplace help women to rise in education and so forth. Women in the less developed countries I've worked in, actually, often marry young, have many children, and cannot be as reliable in the workplace as the men, and so it's very difficult for the enterprise to invest in women's education and improvement, because the women so often are not the workers who can stay in the workplace for very long, or who can be there on a very reliable basis. And as far as the children are concerned, the children often are dependent on, especially by families whose parents can't earn too much, to go into the workplace and earn whatever they can, and they may be, not too educatable because of their age. Don't you think that it's more important to address the problems of these kind through the general social positions of the government towards birth control, dissemination, and health benefits, so that the women don't have to have so many children in order to have just a few of them grow up to adulthood?
Do you want me to go ahead or wait? See if we have other questions.
Do we have any other questions? We've got one here.
Thank you. I'm Don Shirk with PACT. I'd be interested in having the panelists address the question whether or not the other G8 countries see this issue of labor rights in some comparable fashion, or is there a differentiation among those countries in the G8? Perhaps you might want to speak to the OECD. Is the U.S. way out in front? Is the U.S. on comparable terms with other G8 partners, or how does that work out? Thank you.
Any other questions?
I just wondering if you could speak a little more. Could you just speak a little more on the one that I asked earlier? It didn't seem like anybody directly answered how these different mechanisms stack up against each other. Maybe Dr. Moore.
Okay. Thank you for your question, and I'm glad that you asked that question, because I think that it highlights a few things that I had tried to incorporate into my remarks too. I don't think trade policy can do everything, nor do I think trade policy should do everything. It can't address every problem, and it should not be the sole focus. We do still need to look at things like healthcare and education and all of these other aspects in order to come up with the right answers. So it's not the answer to everything, but I think that to the extent that it exists, and I think it will always exist, it could be used better to help improve the lives of women around the world. And that really is the perspective that the group that I work for tries to focus on. We also work on development assistance and looking at many other issues as well. So trade is just a part of it. It's just a piece. But it does have the potential to impact so many women's lives. And I think that part of what you said, too, really resonated with me, because the issues that women face when entering the workforce and staying in the workforce and balancing all of the many things that women balance, whether it's taking care of their families or gathering fuel and water for their families, which can take hours and hours a day, are very different than the realities that men face. And if we don't look at all of that when determining what the best policy should be, we're leaving out over half of the world's population and the people who really stand to benefit or to lose from these programs and these policies. So that's part of the reason, too, that we've long advocated to do a review of the development implications of trade policies and other policies as well, to look at those things and to bring those to the fore, because I think that many times the people who are up negotiating trade agreements are not thinking about all those things, and not because there's any fault on their part, but I think that you have to really experience them firsthand sometimes, or talk to people who do, to know what those concerns and those considerations are. So I thank you for raising it, and I think it's a very, very valid point. And I don't know if I should attempt to answer your question, but I think that just to say one word and then turn it over to the professor, that many of these programs target country practices, and I think that part of the targeting does have to be on the countries themselves, since the country governments are the ones that are making decisions about which laws to pass and very often how to enforce those laws. I agree with Professor Moran that if you look at the companies specifically, that you get into this dangerous game of, sometimes taking away jobs where there are, precious few jobs to be had. But again, the quality of those jobs needs to be a huge consideration, and just having jobs there is not always enough. But I think that there's one other piece too that we didn't really touch upon, since we're talking about trade policy, and I just want to flag it very briefly, and that is the power of the individual, both as a worker and as a consumer, to also make decisions in this regard. And I think that the more that these discussions happen and the broader that they become and the more stakeholders become involved, the better the solutions will be, because everybody has a stake in this discussion. And there are ways that I hope that if more and more of the public becomes aware of these issues as well, that can help shape the way that things are done. And the way, I think you've got to have both a way to enforce problems, and you have to have incentives for good behavior. And if you take away the incentives, then the system just is lopsided and doesn't work. So as we look at trade agreements and we look at trade preference programs, we have to look both at sort of what is the bright line for being part of it, what happens if there's a problem, and how do you take action, but then also how do you encourage more programs like the Cambodia program or like what Sri Lanka is working to do? How do you make sure that trade policy supports that kind of innovative change and really allows it to flourish? So those are just my 2 cents on your question.
Ms. Raffel, let me address your issue, and I do this with considerable humility because as Ann and I work together on one of this, there is a gender dimension to globalization which I was not fully aware of when we started our work. And what you find is as women come into the formal workforce and work even in the garment factories and footwear and toy factories and jewelry factories, etc. The primary data I think we looked at is from Asia and from Central America. You find that they marry later, that they have more knowledge about health matters, including reproductive health. There are even agency issues. I mean, that they actually participate, they have more power to participate in choosing who they marry. Now, this is in comparison to what? In comparison to what it would be like back in the village. So, I mean, you're not comparing, very promising sectors. But on balance, and then fewer children and better maternal health and better child health, et cetera. So the statistics, the gender literature on this is not just about how women are being exploited, but also about now, as in everything, this is not a rosy picture. I mean, that there are also exceptions, and there's lots of physical abuse and sexual abuse, and I mean, so it's a very mixed picture, but you also get some good news as well as some bad news. Now, turning to the separate question, no, these models haven't been tested. I would agree with my colleagues if you look at the bilateral, and it isn't just U.S. bilateral, there's also data on European bilateral preferential arrangements, you probably would come out with about a B+. I agree, it wouldn't be A, and it could have been better, and it could have been different, and Cambodia did this, and Morocco did that, and Jordan did. But in general, and what we saw, there is just a lot of consciousness raising. I mean, 10 years ago, there, labor ministries and didn't have that much clout, and people didn't pay that much attention to them and everything. And now they're talking about judiciaries and laws and getting better, and capacity building. Yes, 16 times isn't enough. You can do it 116 times, because you look at the report from the vice ministers in Central America, and every third page, what they do is they talk about they need more money for enforcement or for training or for, so that all goes hand in hand. But I would say on a bilateral basis, it has looked fairly positive. We don't know what it would look like on a multilateral basis. If this discussion has been too opaque, let me say I may be the only one who is harboring some doubts even about the current template. I mean that because, you know, I was telling Howard, I was down in Peru, and if you go around and look at the factories that are growing up around the port area just outside Callao, I think is the name of it, just outside of Lima, making hats, you know, there are all kinds of the things, solidarity, you would identify. I mean, the lack of collective agreements, there's lack of collective bargaining, etc. Now, suppose we get the free trade agreement with Peru, and somebody brings a case, and somebody brings a case and they win. Then you ask, how does this process work? Well, I would turn it over to Lewis or to other people to talk how the Washington process of figuring out the retaliation list works. But in general, what you do is, you know, you figure out how you can punish. I mean, you can go back and think of how the U.S. and the Europeans have thought up multi-billion-dollar packages to punch each other in the nose. I mean, it wouldn't be like that vis-a-vis Peru, but you know, that's the kind of thing. Who would you pick? I asked myself when I was there, if you were to do a package, if Peru lost a case and Washington or somebody else were to try and bring a case, you'd pick BHP Billiton, second largest mining company in the world that is, you know, doing huge copper, gold, silver stuff, and you pick Mariner Neptune. I'm sure that's a household word. Well, it's one of the Canadian shrimp and fish packaging, both of whom have high labor standards. Nobody's ever going to bring a case against either one of them, but you would whack them to get the guys doing hats, not allowing collective bargaining in the hat. And this is the kind of trade-off. It's very punishing. And then you'd have to say, are you better or are you worse off if you got involved in that?
Yeah, I could just ask a question on that issue. I mean, the issue of the Costa Rican Intel plant. My guess would be that the chance of the U.S. punishing Intel for the Nicaraguan migrant banana workers would be slim, because I'd imagine a lot of Intel's trade with the United States is intercompany transfers, and you would not think Intel here would put a significant amount of pressure on USTR not to take it out on Intel, but actually on the sector that is actually causing the problem.
Yeah, in fact, why don't you guys describe how that process works? Because you have a vision. What do you say, 20 years of experience in doing this?
Yeah, I'm not sure these provisions have been around for quite 20 years, but apparently I have them, as was pointed out. Well, I mean, there's a lot. I mean, this is a lot of hypotheticals.
Yes.
Involved here, but and since these provisions are new, and in the past, frankly, we have not had the idea that if you were to have a dispute on labor provisions, the remedies were not the same as they are in the new template. The new template is that the remedies would be the same as they are for commercial provisions, and you could take some trade action, basically taking away a benefit, but the country could choose to pay, in essence, a fine, an assessment, rather than lose that trade benefit. So if a country wants to avoid actually having a trade sanction against them, and they could do it by paying an assessment if they chose. But let's remember that even if you were to win a case, it doesn't necessarily mean you jump automatically to taking some trade action. There's certainly, as with commercial disputes, there's discussions between the countries about trying to find a way to address the issue. Hopefully you would convince the country that they should take whatever action is needed to assure that the laws, if the problem is that there's laws lacking and they don't provide for the fundamental rights, hopefully they would take the necessary action to do that. If you're talking about enforcement of law, they would take the necessary action to enforce the law. So there's all those opportunities, of course, to try to get the country to address the issue specifically. It's only if they didn't do that that you would then look towards the trade sanction and some other means with which to get them to take action. And certainly I think, as with commercial disputes, we're not going to preclude using one method or the other, or one means of pressure of the other ahead of time, and saying how you may want how to do it. It would depend upon the country, obviously. It would depend upon the extent of the problem and how reluctant the country is to address the issue, I would think. And you'd have to weigh those factors and determine what is the best way to prod them to take the action that they ought to take. Jeff, I don't know if you want to.
No, I agree.
Briefly, let me try to answer the other question about our other G8 countries or OECD members and how they're addressing these issues. I mean, obviously I'm a little biased in that regard, but I think the United States is far ahead of any other country in the world on pushing these issues. From the standpoint of a country that is insisting upon these types of provisions in our trade agreements. Obviously, worker rights provisions in preference programs. There are other countries that have those. The EU has recently created its GSP Plus program, or added these worker rights provisions to the GSP Plus program that basically requires countries, if they want GSP Plus, to ratify the 8 ILO core conventions, to ratify and implement them, I believe. The jury's still out a little bit on what they mean by implement and how they might measure that, but they've laid those requirements out. And then more recently, the EU indicated that in their bilateral trade discussions and agreements, that they would start talking more directly about labor and social issues, and I don't know if they have quite worked out exactly what those provisions might look like, whether they'll be placed in the body of those agreements, but they certainly have indicated the intention to do that. My understanding is that they have recently started negotiations with Korea and either have or will be raising those issues. So you've seen that in the EU. Canada, of course, is our partner in NAFTA and has had these provisions and has continued to include labor provisions in its trade agreements with Chile and with Central America, and as far as I know, has put it on the table in its other negotiations. You've seen some support out there. I think New Zealand has raised these issues in some of its agreements. I know Chile has, and they're not an OECD member, but they might be one day soon. I'm not aware of Japan raising these issues. No. But there are other countries out there raising them, and I think you are seeing increasing interest, among G8 members and OECD members to talk about these issues and have a discussion about what are the different countries doing, and possibly 20 years from now, seeing those converge rather than diverge.
My name is Carlos Quintana. I work at the Department of Labor. And my question is related to the impact that you think that the new template will have on existing enforced FTAs. I see a situation where you have the Catholic countries and you have Panama with two different worker rights standards. Is there a concern that you might have, the lower standard might attract investment there, and there may be a need to actually go back and either renegotiate or reach another agreement so that the standards will be equalized, with existing FTAs. So what are the prospects of that happening, I guess is my question.
Do we have any other questions? Doesn't look like we have any. Yeah.
I'm Nimal from Sri Lanka Embassy. I just would like to know whether the US government has any intention of introducing something similar to GSP Plus introduced by the EU, because we find the EU has taken real effect. For Sri Lanka, we are, I think, one of the beneficiary countries in the whole of Asia for EU GSP Plus, which we got from 2005. It took some time for us to improve certain conditions both in the field of environment and labor. But finally we managed to get the GSP Plus status, and we see a rapid improvement of exports, growing exports to the EU market. So if there's a way to help developing countries, I think it would be best that US also consider something similar that benefit countries which really comply with these different standards, both in the environment and labor. So question is whether there's any possibility in the near future that US looking at the same direction. Thank you.
Any other questions? Okay.
It would just be my guess that people would not make investment decisions based on the CAFTA versus Panamanian labor chapter. I think the investment decisions would be dependent on infrastructure, many other conditions, and maybe labor conditions. But the question of the actual labor standard of the FTA, I think, would have a minimal at best decision on investment decisions. But that's a guess.
Yeah, I mean that would be my guess as well. There's a lot of decisions, a lot of factors that go into companies making decisions about investment. I think clearly having trade agreements is an important aspect. It creates that permanent relationship and creates rules-based systems and leads to improved institutions and transparency and everything that goes along with it. I would like to think that the stronger labor provisions actually would encourage more investment, because it's another factor that's indicative of a country's commitment to rules-based systems and operative institutions and things of that sort. So that would be my hope, that the stronger the provisions, the more that it encourages investment. As far as the question about GSP Plus, I really can't answer that. I don't know, what the intentions may be with regard to that. But I mean, we do have programs like AGOA and ATP DEA that are GSP Plus in that sense. They are a wider array of products and entry to the U.S. market. But I'm not aware of any indications to have additional programs of those sorts for other regions. But there may be.
Just one quick note on that. The discussion that's going on right now, I think, on Capitol Hill over how to reform the preference programs, I think could maybe address some of these things. It may not look exactly like the European program. I think each country, as Louis was saying, has a different GSP type of system. But there is a lot of attention being paid to whether market access should be expanded for least developed countries and for other countries that are very poor around the world, and also to how some of these other things should be looked at in that context as well.
Got about 10 minutes left. If there's any questions, you've got time.